We have understood what is the government and the legislatures of all state. We have understood what exactly is local authorities, which is going to be governed by subsection 3 of General Clauses Act 1897. But still there is one confusion, that what exactly is the other authorities. So in order to understand that what exactly is the other authorities, and since there is no specific mention under any legislation what exactly is the local authority that has been mentioned in Article 12, it was a dire need to get the interpretation of the Constitution by the court. As you know that the court, Supreme Court specifically, is considered not only to be the guardian of the fundamental rights, but also to be the interpreter of the Constitution of India. So there has been different legislations, but in different legislation we don't find mention of any example and definition of what would be the exhaustive criteria of understanding other authorities. So there has been different cases that has been coming and going in the different courts, through which there has been creation of precedents, which helps us in understanding that what are those areas or what are those authorities which can be considered as a state. So we are, and it is a very important that we are understanding through the understanding of all the different all the different precedents or the cases where which the definitions of other authorities has been dealt with. So let's move forward and try to understand what are the different authorities or the other authorities as specifically provided by the different interpretation of the Constitution by the courts. So now other authorities, if we understand the general terminology, authority is established by the Constitution of India or by the statutory authority established by the sovereign government. So if we talk about the local authority, if we talk about the other authorities, it is a prerequisite that any other authority which has been created by the Constitution, first thing, that creation by the Constitution, by virtue of the Constitution that has been created, then it will be considered as other authorities. And then if it has been created by the government, if it is being created by the government, then also it will be considered as other authorities. And if there is an infringement of fundamental right by those authorities, then the other authorities we can also claim fundamental rights against those authorities as well. This particular segment was discussed. If you can see the cases here, important case laws which has helped us in defining other authorities. The first case which talks about other authority is the University of Madras versus Shantabai. It said that if there is any authority which is doing the work as the same of the government, that is justum generis. This is a latent terminology which means of the same kind. The same kind. So in this case law, while interpreting what exactly will be considered as the authority, the court observed that any authority, if they are working as the government authority and doing out or carrying out the work of the government, they will be considered as other authorities and they will be held liable as under Article 12 of the Constitution of India. But this contention was actually removed and rejected by the case of Ujjambai versus State of Uttar Pradesh 1962, where which this contention of justum generis was rejected, and it was contended that there is a need to understand and develop areas which can help us understand what is other authorities. What is other authorities? So again, in the year 1967, there was another case law, Electricity Board of Rajasthan versus the Mohan Lal of 1961, which said that if there is any authority which is created by the Constitution of the statutory authority that has been defined the same way in the in the University of Madras versus Shantabai case, it was clearly told that any authority that has been created by the constitution or by the statutory, that is the government, the sovereign government, it will be considered as a state. Then there are other definitions or other areas which help us in understanding that which provide us a detailed framework which increase the scope of understanding what will be the definition of the state. In the same way, there was one case with the name of Sukhdev. This is not Sutdev, this is Sukhdev. Sukhdev Singh versus Bhagat Ramand of the year 1975. It held that statutory authorities include LIC, Life Insurance Company, Corporation, ONGC, IFC, etc. all are considered as statutory authorities, and that's why they are considered as state under the definition of Article 12, which is related to what? Which is related to fundamental rights. In the same way, there was another case with the name of R.D. Shetty versus International Authority of India, where for the first time the word of agency or instrumentality was taken into consideration. What it said was that if there is any company or organization which is working as the agent or instrument to carry out the working of the government on behalf of government, then these agents who are working on behalf of the government for the government will be considered as state. And that is why the Airport Authority, International Airport Authority of India, International Airport Authority of India, IAAI, was considered to be the state. In the same manner, there is another case, and this is perhaps the most important case if we talk about in regards to your CLAT competitive examination, and that is Ajay Harsia versus Khalid Mujib of 1981, which defined a test to check authority of the government, because there was confusion that whether to what extent the authority of the government is needed to consider a particular authority to be defined as state under other authorities. So it was getting a lot of confusion that in the earlier cases it was mentioned that if there is even a small amount of control by the government, then that particular organization or the authority will be considered as state as defined in Article 12. But there were certain areas which needs to be rectified. So in this particular case, Ajay Hasya versus Khalid Mujib of 1981, we got the opportunity to understand that what are the tests which are going to help us understand that these authorities are the government authorities or not. So the first thing that was explained in this particular case was that the entire share capital should be with the government. This is the first requisite. The second thing is there should be deep persuasive control, that the government should have deep persuasive control. Third being that it should be of public importance. It should be of public importance. And the third is the monopoly status. It should have the monopoly status in the eye of the government in that particular area. So if these four requisites are present, then that particular authority is considered to be the other authorities under the state definition. Then again, there was a case of Pradeep Kumar Biswas versus Indian Institute of Chemical Biology, where which there was a dispute in regards to whether this particular person, Pradeep Kumar Biswas, should be given. Why is it so that he has not been given the same amount of revenue as compared to the co-workers? And the case was taken up to the Supreme Court, contending that there is the infringement of his fundamental right of equal pay for equal work. And in that particular argument, the Indian Institute of Chemical Biology stated that it is not within the ambit. Indian Institute of Chemical Biology is not within the ambit of state as defined under Article 12, and therefore there is no infringement of fundamental rights. So that is perhaps the reason the court, it was the contention of National Institute of Chemicals, and Pradeep Kumar Vishwas contended that since it is an organization which is working for the benefit of the nations as such, and the national policy and the national upliftment is taken into consideration, that is why this particular institute is also under the state authority. And that is why by the Supreme Court's reiteration, it was held that since it is for the national interest, that the definition is of this particular institute, it is for the national interest they are working. So obviously it is for the public importance as has been defined under the Ajay Hasia case. And since it is of public importance, it comes within the ambit of other authorities as it is being controlled by the government itself. So it makes sure that by these case laws, we are getting now a clear pictures that what will be considered to be a state and what will not be considered to be the state. Moving forward, then there was another argument and other problems that we needed to understand is that judiciary is also considered to be a government organ. If we see that what exactly are the government organs, that we know that the government is divided into three major parts. It is legislature at the initial, then you have the executives, and post-executive you have the judiciary. So it was contended that if the judiciary is included under the definition of state, then if somebody is accused and he is tried and he is found guilty, then he might again resort to the judiciary seeking protection under Article 32, or that is known as constitutional remedies, for release, claiming that his fundamental right to liberty is curtailed. So you see that if there are chances that if we include judiciary in the definition of state, then it might become obviously it becomes a very hectic problem, because whenever the judiciary will be giving detailed orders or judgments, the orders would have been called into question on the basis of on the basis of being under the definition of the state, and on that basis all the judgment would have come into conflict. So this particular argument or conflict or contradiction was actually removed in the case of A.R. Antule versus R.S. Nayak. In that particular case, it was observed that judiciary, whenever they are performing the judicial functions means that they are working for providing justice, they are seeking or they are providing orders, or whenever they are resolving any dispute, at that point of time, any judicial work whenever they are doing, then at that point of time they shall not be considered state as defined under Article 12. But whenever they are doing any administrative functions, then that work will be considered as state. So this is a small difference that was put forward, and that becomes a very important point of discussion, because whenever the judiciary is doing any administrative functions, it can be challenged in the court of law. But any judicial functions which has been given cannot be considered as state, because that will obviously be causing a lot of conflicts in the coming time period. So that is what is actually has to be understood when we talk about the case of A.R. Antule versus R.S. Nayak, which provided us a detailed framework that whether judiciary will be considered as state or not. Moving forward, there were another case laws also which has provided us with some important requisites of who all will be considered as authorities. And the reason for understanding other authorities because we are actually seeing the scope. We are seeing the scope of Article 12, which is going to provide that against whom infringement of fundamental rights, if done, can be restored by Supreme Court, and actions to be taken against them. So in the same manner, in the case of Chandra Mohan Khanna versus NCRT 1992, NCRT is considered not to be a state. So NCRT is not a state according to this particular case law. So if there is any action that has been done by NCRT, we cannot go to this to the court and seek the infringement of fundamental rights, because it is not the state according to the definition of Article 2. In the same manner, Zee Telefilms versus Union of India 2005, it was held that BCCI is not the state. BCCI stands here for Board of Cricket Council of India. That is also considered not to be a state. In the same way, Sanjay Behel versus Union of India in 2019 made that United Nations organization is also not under the ambit of state. In the same manner, the Tekraj Vasanti versus Union of India. It is a very important case. It was asked in previous competitive examinations in the year 2021 that whether Institute of Parliamentary Studies is a state or not, and it was held that it is not a state within the definition of Article 12. And so any infringement of fundamental rights by this particular institute, the remedy of resorting to Supreme Court for restoration of fundamental rights is perhaps not possible. And Som Prakash, this is an important case because in this particular case, Bharat Petroleum Corporation, the fuel industries which you have seen majority of the time whenever you go and get your vehicle refueled, that Bharat Petroleum Corporation, the main company, is considered to be the state because it is obviously under the control of the government and it has deep persuasive value, and obviously it is importance for the public welfare also. Okay, so I suppose you are well versed, understood that what is exactly the scope, and it is not exhaustive within this particular case laws only. The ambit of the state has been defined and increased by the different cases, by the different legislations, by the different interpretations, and that is why it depends on the facts and circumstances of every case that whether the person or the authority against whom the infringement of fundamental rights is being accused of has to be considered whether they fall within the ambit or the definitions of state or not. We have tried to increase the ambit by providing the different areas on which we can say that these case laws are providing us with a detailed framework as to what exactly is the definition of the state. But as I've just explained to you, this definition is not exhaustive, and that is why it becomes important for you to first read the case, try to understand the case, and then eventually understand whether it is falling with the definition of state or not. So with this, we have completed Article 12. We have tried to understand that what will be the definition of state and against whom fundamental rights can be, if infringed, can be restored by resorting to the Supreme Court by virtue of Article 32, which talks about the right to constitutional remedy if there is any infringement of the fundamental rights. And these are the case laws. Now let's move to Article 13. Article 13 is talking about pre-constitutional and post-constitutional laws. It is talking about pre-constitution and post-constitutional laws. So as you know that while creation of the constitution, it took us around a lot of time period, but it was not like that there were not laws that were being governed, that were being governing the countries as such. But by the incorporation of Article 13 in the Constitution of India, what we made sure is that if there is any provision that was, or any law or any act that was created prior to the constitution and it is in conflict or in derogation with the fundamental rights, are considered to be void. Void means not valid. So void here means not valid. If it is in conflict or is inconsistent with the provisions of this part, that is the fundamental rights or the part 3, then they are considered to be void. And when we talk about post-constitutional laws, so the pre-constitutional laws which is in conflict with the fundamental rights, they obviously by themselves becomes void. They are not enforceable, they cannot be enforced. And the cases or the laws which has been created post the creation of the Constitution of India, all those laws which has been created which are in derogation with the fundamental rights will be considered to be void ab initio. So they will also be considered as void ab initio once there is any law that is being created in contradiction to the fundamental rights. Then what exactly is the difference? In post-constitutional laws, they are also being considered to be void. In the pre-constitutional laws, it is also be considered as void. Then what exactly is the difference? There is a difference that we need to understand, and for that we need to study. There are two principles which is going to be explained here, and the first principle is the doctrines of severability, and then the second one is doctrine of eclipse. When we talk about doctrine of eclipse, as we just understood that Article 13 says that all laws in force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provision of this part, shall to the extent of such inconsistency be void. So this is pre-constitutional. So the first clause talks about the pre-constitutional laws. And what does the second says? That the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this part shall to the extent of the contravention be void. So now here we need to understand the doctrine of eclipse. Doctrine of eclipse says that whenever there is any law that is being created by the government and it is in derogation with that particular law, by that particular fundamental rights, then that particular law will be considered to be void. But when we talk about the pre-constitutional laws which has been held void after the creation of the fundamental rights or the constitution, by the incorporation of the constitution, those laws are not completely removed or vanished or expelled from being abided by. It means that it is not like that they are completely removed and they are not into authority as of now. They actually are eclipsed. Then this is what the doctrine is saying, that they are actually eclipsed. And you know what eclipse is? Eclipse is overshadowing of, and you must have heard about the solar eclipse and the lunar eclipse. In the same manner, when we talk about eclipse, what the constitution makers want us to understand is that post incorporation of Constitution of India as such, all the laws that were created has been eclipsed by the constitution, and if they are getting in contravention to the part of the constitution, then it will remain eclipsed and it cannot be enforced. So it means that they although the rights are there, but the rights cannot be enforced because it has been eclipsed by the parts of the constitution. And once those parts which is eclipsing the pre-constitutional laws, those parts which were eclipsing the post-constitutional laws has been removed or has been altered or has been changed, then that particular old law which was eclipsed by the provision of being inconsistent by the constitution will again be enforceable. So that is what is doctrine of eclipse. The doctrine of eclipse says that if there is a pre-constitutional law which has been considered void by the incorporation of Constitution of India, it doesn't become obsolete, it doesn't come to an end, but rather it has been eclipsed by the provisions of the constitution. And if at all in future the constitution makers or the legislators feels that there is a need to alter the constitutional framework, and after alterations it is seeing that the eclipse over that particular law has been removed, then it shall become enforceable. And that is the doctrine of eclipse. And when we talk about doctrine of severability, so as you see that in the second clause it is mentioned that the shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall. Till this particularly I suppose everybody is clear. Yes, to the extent of the contravention only, be considered void. And that is what doctrine of severability is talking about. So doctrine of severability suggests that if there is any legislation that has been created, okay, so let's take this as a legislation. Okay, so this is the legislation that has been created, and out of these 5 clauses we find out that these 2 clauses are against the constitutional framework. So the doctrine of severability says that only those areas which is in contravention of the constitutional framework should be considered void, and the rest of the areas which are not contravening the constitutional framework shall be enforced, and they will not be considered as void. And that is what severability, doctrine of severability is talking about. So severability basically means separatability, separating void laws from valid laws once we figure out that only this particular portion of the laws is being considered void and the rest of the laws can still be enforced. So we use the doctrine of severability, and by that particular doctrine we only take out those parts which are not contravening by the provisions of the constitutions, and those parts are considered to be enforceable, and the parts which are actually being contravening the constitution, they will be considered as void. So these are the 2 doctrines that one need to understand. We will obviously be studying the case laws of FN Balsara versus State of Bombay, which is again going to define the major areas of doctrine of eclipse, we will be studying about uh, Bijnor versus state of Uttar Pradesh, and then we will be studying about Mysore versus state, and we will also be studying a case of Balaji Telefilms Limited. All these case laws are going to explain us that what are the important how these doctrines have been made applicable in the real time perspective, to figure out that these principles can be explicitly governed through these doctrines. In FL Balsara, the doctrine of severability was taken into consideration, and in Bijnor versus Uttar Pradesh, the doctrine of eclipse was taken into consideration. So I suppose that you are well aware and acquainted by what exactly is the doctrine of severability and doctrine of eclipse, and what exactly Article 13 is actually talking about. That if there is any inconsistency of the in the pre-constitutional laws, then doctrine of eclipse becomes enforceable, and if it is, it can again be restored once there is an alteration in the constitutional framework, more specifically the fundamental rights. Now, what exactly the law means here? If you talk about laws, whether the laws includes amendment also, because if the amendments can be altered or changed, if they are being considered inconsistent by the fundamental rights, then obviously it becomes a difficult point for the constitutional makers to implement if there is any inconsistency, and the whole point of creating Article 30 becomes invalid. So that is why, in order to make sure that this discrepancy is removed, this particularly subsection 3 of Article 13 provides us the detailed framework as to what exactly laws are. So this says that laws are includes ordinance that is being passed by the president or the governor when the legislation or the house is not in session. Orders given by the government, by the courts, bylaws, rules, regulations, notifications, customs or usage having in the territory of India the force of law. Law enforced include law passed by or made by the legislatures or other competent authority in the territory of India before the commencement of the constitution and not previously repealed, notwithstanding that any such law or any part therein may not be in then operation either at all or in particular areas. So this is, and then there is one more clause that has been mentioned, that it does not include amendment as mentioned under Article 368 of the Constitution, which is talking about the amendment procedure, that how the amendment needs to take place. So this exactly summarizes us with the detailed explanation of what exactly a state is, against whom we can incorporate, and we against whom we can get our fundamental rights restored. So now we have understood that okay, these are the areas against whom, or authorities against whom, we can get our fundamental rights restored. We have understood what exactly is fundamental duties. Now we are left with the most interesting and the most important portion, and that is what exactly are our fundamental rights. So the first and the foremostly what we need to understand is that what will be our rights. So the first rights, that if we talk about in a layman term so that it can be cleared afterwards, is right to equality. This is our first fundamental right. Then you have freedom, fundamental freedoms that has been given to all the citizens. Then you have cultural and educational rights. Then you have rights against exploitation. Then you have right to life, and then you have right to constitutional remedy. Okay, so if we define, if we describe that how the different areas can be divided, uh, you will see that the constitution, see if there's particularly there are six fundamental rights are there: right to equality, right to freedom, right against exploitation, right to freedom of religion, or you can say that it can be divided into right to life, and then right to life you will find mention of freedom of religions also. Then cultural and educational rights and right to constitutional remedies. There was one more article that was there, then that fundamental right was there, that was right to property, which is now been converted as a constitutional right under article 300A of the Constitution. Right to equality, right to freedom, right against exploitation, right to freedom of religion, culture and education right to constitutional remedy, and right to property has been removed from the fundamental rights, and it is now not anymore a part of the fundamental rights as such. Okay, so now we will be discussing about our right to equality that has been mentioned under Article 14 to 18. Then after that, we will be talking about the fundamental freedoms in our upcoming lectures. Then after that, we will be talking about right against exploitation. What exactly is right against exploitation? Then how we are going to provide freedom of religions, to what extent the religions are there, culture and educational rights, what exactly is there, right to constitutional remedies, what exactly how we are going to uh, get our rights if they've been infringed, being revised and restored. And here we will be talking about writs. There are 5 types of writs that we will be talking about. We will be talking about habeas corpus. This is first. Then we have certiorari. Then we have quo warranto. Then we have prohibition. And then we have mandamus. So these are the 5 writs which has the power been given to Supreme Court by virtue of Article 32 and High Court by virtue of Article 226 of the Constitution of India. And both the High Court and the Supreme Court have the authority that if the fundamental rights are being infringed, then obviously they can resort to the respective courts and get the fundamental rights restored. But why is it so that the Constitution has considered Supreme Court to be the guardian of the fundamental rights? Because he is the supreme, it is the supreme command in regards to what exactly will be the criteria if at all there is any infringement of fundamental rights, and their say is full and final, which cannot be appealed, which cannot be challenged. And that is the reason it is the Supreme Court who is considered to be the guardian of the fundamental rights. We will be studying all these writs, which are very important in regards to your exam point of view. We will understand that along with the different case laws that is being included in it. And post that, once we are completed with the fundamental rights, we will be resorting to another important portion of the Constitution, and that is understanding in detail what exactly is the directive principles, how the emergency provisions is being uh, uh, emergency is applied in India, and what is the method of amendment, and a little bit of information about how the parliament work, who is the speaker, who is the ex officio chairman of the country, how the money bill and the normal bill is being introduced. These are the some important aspects that you need to understand whenever we are going to prepare for competitive examinations like CLAT and everything. After completion of the constitutions, I will be focusing towards the law of torts, perhaps one of the most important and interesting topics when it comes to the preparation of CLAT. And although the topics are so easy that it will be very much understandable in a one go, but it requires you to practice a lot in this particular examination, as I've already suggested it to you. So it becomes very important to you for you to start practicing again and again. We have completed till the fundamental duties and first portion of fundamental rights. We have completed the criminal law, we have completed the court the law of contracts. So I would advise you again to continue to practice your paper, and post completion of this constitution we will be providing you the list of the important cases that one candidate is supposed to retain and remember whenever they're going for the preparation of the CLAT examination and they're going to sit for the examinations as such. With this, I thank you all for being here with me and understanding the topics as such. We wish you again the best of luck. Please remember the three principles that I've been explaining to you from the right of the beginning of this lecture series. Principles, that is the applicability of the principles, the practice, and the persistency is what the three mantras, the three P's which a CLAT aspirant should keep in mind whenever they are preparing to succeed in the examination of CLAT. Thank you so much, guys. I wish you the very best of luck. Let's meet in the next video. Bye bye. Take care.